Justices of the Court, my name is Tembeka Ncukaitobi. I appear with Mr. Maputla and Ms. Kentridge on behalf of the Competition Commission.
Thank you, Mr. Ncukaitobi. Mr. Bana. Mr. Bana, are you with us? Oh, something must have happened. And who's appearing with Mr. Bana?
The gods.
Mr. Court.
Good morning, Justices. Mr. Bond is sitting on the opposite side of the table for me. He's just having a few connection issues. He should be in.
Justice Madlanga, Mr. Bana has just been readmitted.
Thank you very much, Justice Theron. Thank you, Mr. Court. Mr. Bana. Mr. Gotts, why don't you and Mr. Bana swap devices?
I might do that, although mine is far more primitive than his is.
But I guess primitive is reliable in this instance.
I think he is being readmitted at the moment.
He has just again been readmitted, Justice Madlanga.
Okay, let's see then.
Apologies, Justice. Can you hear me and see me?
Loud and clear, and yes, we do see you. Thank you, Mr. Bana.
I apologize for that. We were kicked out and then brought back in.
No problem.
Justices, I appear for the respondent group 5 together with Mr. Gotts and Ms. Avedon. And may I please take the opportunity to thank the court for its indulgence for the late start due to the religious holiday and commitments. I'm deeply indebted to the court and to the justices.
No, that's something we had to accede to, Mr. Bana. Thank you very much. Yes, Mr. Ncukaitobi.
Thank you, Justice Madlanga. The court would have seen in volume 5 the extensive application for the leave to appeal, and the court would have seen our heads of argument, which are also extensive. What I propose doing is to focus on 2 key submissions that we submit the appeal should turn on. The first is to argue that the issue in the review application before the High Court fell under the exclusive jurisdiction of the Competition Tribunal. The second is to argue that on a proper construction, Section 62 of the Competition Act should be interpreted in keeping with the legislative purpose to create a specialist forum to deal with competition matters, specifically the investigation and prosecution of cartels. The approach of the High Court, which has been endorsed by the Supreme Court of Appeal, defeats the legislative purpose of creating a specialist and expert-based forum. On the first issue, the correct starting point is Section 62 itself. That section, the court will recall, provides in Section 62(1) that the Competition Tribunal and Competition Appeal Court share exclusive jurisdiction in respect of the following matters: A, interpretation and application of chapters 2, 3, and 5. And then it has certain exceptions, one of those being a question or matter referred to in subsection 2. In subsection 2 of Section 62, the High Court still has no jurisdiction, but that is the jurisdiction of the Competition Appeal Court to deal with among others, constitutional matters arising in terms of the Act. And then Section 62(3) introduces the High Court because it holds that the jurisdiction of the Competition Appeal Court is not exclusive or final in terms of in matters relating to subsection 2. What is clear, though, is that the jurisdiction of the Competition Tribunal, where it exists, is exclusive. It is always exclusive jurisdiction. Now, there is no provision, unlike the cases that this court has dealt with, there is no provision in the Act that provides for a concurrent jurisdiction between the Competition Tribunal and the High Court. And that means that the effect of the finding of the Supreme Court of Appeal is to deprive the tribunal of the jurisdiction in relation to matters similar to the matter that is before the Constitutional Court today. Because a matter either falls within the exclusive jurisdiction of the tribunal or it doesn't. It cannot be shared with the High Court. It is only shared on an exclusive basis with the Competition Appeal Court. So with that framing of the issue, I should then deal with the first question, which is the question of the correct construction of the pleadings. 3 judgments from this court have held that where an objection to jurisdiction is taken at the outset, the pleadings properly interpreted would determine the question of jurisdiction. The first case this court knows is the case of Chiro versus Transnet, and the passages that are relevant is paragraph 155 and 169. The second case is Gaba versus Minister for Safety and Security. The relevant paragraph is paragraph 75. And this is where the passage comes from in paragraph 75. It states, in the event of the court's jurisdiction being challenged at the outset in limine, the applicant's pleadings are the determining factor. They contain the legal basis of the claim under which the applicant has chosen to invoke the court's competence. And then it continues later on. It says, if, however, the pleadings properly interpreted establish that the applicant is asserting a claim under the LRA, one that is to be determined exclusively by the Labor Court, the High Court would lack jurisdiction. So the key question then is, what claim do the pleadings properly interpreted reveal? The last case that is relevant in this line is the case of Baloyi, recently decided unanimously in 2021. And the relevant passages there is 34, 35, and 36. And that is where the court engages meaningfully with the claim that is pleaded by Ms. Baloyi. And it finds that on a correct interpretation, the claim that was pleaded by Ms. Baloyi is a claim in contract and also a claim under Section 182 of the Constitution. So that's the framework that this court has endorsed in relation to cases that implicate PAJA and the LRA, and also in relation to cases that implicate the LRA and the contract, and in relation to cases that implicate contracts of employment and the provisions directly of the Constitution. So the departure point then is to look at what is the case that was brought by the applicant. And that argument is separate from the second argument I will be advancing about the need to interpret Section 62 to preserve specialization and expertise. The case appears from the records initially at page 9, paragraph 7.1 to 7.3. The first claim that is made by the applicant in the High Court is that the Commission failed to initiate a lawful investigation and look at the words that come thereafter in paragraph 7.1 in terms of the Competition Act. So this is a claim brought squarely in terms of the Competition Act. And then the second allegation made is paragraph 7.2, which is at page 10 of the record. There the claim is that the decisions were taken in breach of the undertaking and the grant of immunity. And the immunity provisions, I'll come back to those, they arise squarely under the Act. And the last claim is paragraph 7.3, which is a claim of oppressive, vexatious, and bad faith prosecution. But as I will show, those claims also, their substantive basis flows directly from the Act. We see the expansive treatment of these grounds of review from paragraph 64, which is at page 35 of the record, where each of these grounds is then dealt with. The first ground, which is the issue of the initiation. The substance of the complaint is that the Competition Commission did not have a proper investigation before it made a referral to the Competition Tribunal. But it's clear from paragraph 67 that that is an issue pertaining to contraventions of the Competition Act, and it is an issue pertaining to the breach of section 41A and B of the Competition Act. Paragraph 69 also confirms that this is an issue about the interpretation of the Competition Act. And there the criticism is that the Commission conducted a preliminary investigation before the initiation of a complaint. It is true that paragraph 70 refers to ultra-virus and the legality doctrine, but it does not plead any specific complaint other than the complaint that is in paragraph 67, 68, and 69, which is a complaint that the referral did not comply with the provisions of the Competition Act because there was no valid initiation. And this question then that arises, if I can stick to the first ground, is that claim a claim that is cognizable under the Competition Act or not?
Mr. Ngwaitobi, the 10 minutes is up.
Thank you. That's actually
Please
this is a useful point at which my 10 minutes is up. I want to then ask the question, is that a claim, the first claim, which is a referral without a valid initiation, a claim cognizable under the Competition Act? The answer to that question is yes. Firstly, if we look at the power to initiate, the power to initiate is granted by section 49B of the Act. That's the power to initiate an investigation. This court is familiar with the power to initiate an investigation because it delivered an extensive judgment in that regard. So that you will find at section 49B of the Act under Part C, dealing with complaint procedures, but it is a matter dealt with squarely under the Competition Act. The next question is the power to refer a complaint after an initiation. That we see at section 50, subsection 1, and it is an outcome of a complaint. So you initiate first under section 49B, and thereafter you refer when you initiate the actual prosecution, that is called a referral, but that too is dealt with under section 50, sub 1. The grounds upon which you may make a referral upon an initiation are set out in section 41A and 41B under chapter 2 called Prohibited Practices. So all of those three key statutory provisions flow directly from the Competition Act. It's the initiation, it's the referral, it's the substantive justification for that referral. So if we go back then to section 62, what does section 62 say about when does the tribunal have the power? So Section 62(1)A, the Competition Tribunal and the Competition Appeal Court share exclusive jurisdiction in respect of matters A, interpretation and application of chapters 2, 3, and 5. Now, the power to refer a complaint flows under chapter 5 of the Act. Both the initiation and the referral flow from chapter 5 of the Act. So they would fall under the exclusive jurisdiction of the Competition Tribunal. Similarly,
Mr. Mugaitobi, I'm sorry to interrupt the flow of your argument. My question relates to jurisdiction, and I suppose in a way touches on exclusive jurisdiction as well. Now, there are some, on the assumption that a constitutional matter has been raised in this application, why would it be in the interest of justice for this court to hear some issues that are raised for the first time in this court?
there is no issue that is raised for the first time in this court. Certainly not the argument that I am making, which is, does the tribunal have exclusive jurisdiction or not? That issue was the main issue in the High Court. It was the main issue in the Supreme Court of Appeal. You will see in paragraph 27 of the finding of the Supreme Court of Appeal, it is squarely on the point I'm addressing now. So I've never advanced any argument that the court should hear any issue for the first time. I'm asking the court to overturn a wrong judgment of the Supreme Court of Appeal in which it found that the High Court had jurisdiction and that finding was wrong.
So you're saying that is the only issue before this court?
Yes.
Thank you.
That's the only issue before the court. Now, so I've already explained to the court that—
Mr. Nkaitobi, I'm sorry to interrupt, but can I ask you a question arising from what you've already submitted? Do you accept that the Competition Tribunal under the scheme of Section 62 does not have competence to consider an ultra vires review challenge in respect of an action by the Commission?
No, I don't accept that. The Competition Tribunal has the jurisdiction to decide whether there has been a valid initiation in order to decide whether the referrer is competent or not. An abstract, if that is the substantive basis for the challenge, that squarely falls under the powers of the Competition Tribunal.
Before we go to the question of initiation or referral, just in terms of the scheme of 62, it seems that the ouster of 62.2 from the jurisdiction in 62.1 concerns whether the Commission or the Tribunal has acted within their respective jurisdictions. That's what 62.2a says.
Yes, yes.
So it seems that the Competition Appeal Court has jurisdiction over those questions, although it's not an exclusive jurisdiction because, as you correctly point out, 62.3 says so. So it appears as if the scheme of this is that if there is a challenge to whether there is an action has been taken by the Tribunal Commission which is within its jurisdiction, what I'm calling an ultra vires challenge, that's not something that can be before the tribunal under 62.1 by the express language of 62.2.
Yes, no, Justice Unterhalter, I'm submitting that if the issue, you can, and one should not get sidetracked about the label. If the issue is whether or not there is a jurisdictional basis for a referral, in other words, did you tick all of the boxes for a referral? That is the stock in trade of what the tribunal deals with all the time.
Yeah. No, I understand that. Yes. Your argument is that the proper characterization of the pleadings is that this was an exercise of powers. Yes. But I'm asking you the question as to whether you accept that if there was a proper ultra vires challenge.
Yes, on this leg of the argument, on the one leg of the argument. Take, for instance, the Baloy judgment, where an applicant comes to the court and they say, the public protector has acted contrary to Section 182 of the Constitution. They directly invoke a clause in the Constitution. They say you've acted contrary to it. No one could argue that the High Court should not deal with that matter.
Yes.
Or take a different instance where the tribunal purported to resolve a divorce case, which would be an ultra-virus complaint. No one could argue that that fell within the jurisdiction of the tribunal to decide.
Well, let's take an absurd example. Assuming the commission purported to grant a decree of divorce to someone.
Yes. Yes.
You would accept, I think, that that is not something that would be within the review jurisdiction of the tribunal.
Yes, it's still arguable on what the factual matrix would be in that scenario, but I would accept that in general, that would be outside the scope of the tribunal.
Yes.
My argument now is, sorry, Justice Untitled.
No, please carry on. Please complete your submission.
Yes, my submission now on this leg of the argument is that the law requires you to properly construe the pleadings. On a proper construction of the pleadings, this is the exercise of power by the commission, which is directly provided for in the Act. What is at issue here is they are saying your referral is bad because you don't have a good initiation. Both of those two questions are within scope of the commission, and they are within scope of the tribunal. The tribunal—
Yes, well, isn't that the fundamental distinction as to how to think about the pleadings, which is there are instances where there is a power that exists to initiate, but it isn't lawfully exercised. You
Yes.
say that's within the tribunal's review powers.
Indeed.
Then there are circumstances where there is no power
Yes,
to do what was done, which would be the ultra vires case. And that's what I'm asking you about. Do you accept, if it's a true ultra vires challenge, that's outside the tribunal's review jurisdiction?
Yes, I would accept a proper ultra-virus. I mean, I make an absurd example. A tribunal issues a divorce decree. Now, that's a proper ultra-virus, but it is not an ultra-virus to label the exercise of extant power as ultra-virus. Now,
Yes.
I've shown the two provisions where the power flows, and the only function for the court that I'm submitting is to marry the pleadings with the statute. And if you do that, the outcome you can arrive at is this is the exercise of extant power.
Yes, thank you very much.
Yes. Now, so when you see paragraph 70 purporting to characterize the dispute as an ultra-virus dispute, when in fact the dispute arises squarely from the parameters of the Act, you should not be sidetracked with that. This was the same point made in Fraser by Justice Froneman, a point endorsed in the case of Chirwa. A matter does not become a constitutional matter merely because you call it one. It becomes a constitutional matter upon an analysis of the pleadings. The best example of the analysis of the pleadings is the Baloyi case, those three passages where the court goes in depth to each of the pleaded causes of action and then says those causes of action that are pleaded fall outside of the jurisdiction of the labor court, because the one is about an infringement of Section 182 of the Constitution. The second is an infringement of the contract which is provided for in Section 77.3 of the BCEA. So on point one, there is no other way of construing the first ground of review other than it is a ground that flows from extant power which has been unlawfully exercised. We then look at the second ground of the complaint. We see this at page 37, paragraph 73, up to 75. This is the so-called grant of immunity to Group 5. Now, the complaint here is this. If you look at the beginning of the pleadings, Group 5 goes to town to say what? To say, we engaged with the commission in good faith and showed the commission evidence of other companies that rigged the 2010 bids for the construction of stadiums. Now, you will see their issue around who actually rigged these bids. They give 4 different companies that they say, we gave you the information that there was extensive rigging of the 2010 World Cup bids. And then they say, when we were doing this, we thought that you would give us, this is at paragraph 57, page 31. So they say here, WBHO rigged the bids for the Greenpoint Stadium, and they confessed. Paragraph 57.2, Murray and Roberts rigged the bids for Greenpoint and Peter Mokaba, and the manner of rigging the bid was cover pricing. Stefanotti rigged the bid for Greenpoint and FNB Soccer City. Avenge, through its operating business, Greenacre, also rigged the bids for the World Cup Stadium. They say everybody has been rigging this bid. We also rigged the bids, but we told you that we had rigged the bids, and we engaged with you in good faith on the assumption that we would benefit from the corporate leniency scheme. But what you did, you set up an alternative mechanism, which is the fast track program. And you compelled us to go through the fast track program, in which we would admit that the net profit that was made was 17.5%. And we don't like that, we disagree with that. That is what lies at the heart of this second round of review. We should have been given leniency under the corporate leniency program, but we were not. Instead, the commission did what they call the volte-face and wanted to prosecute us if we did not agree to the terms that were provided to us. Now, unlike the scenario that we found in AgriWire.
Toby, sorry to stop you there. I thought that was also the respondent's case on this immunity is also based on the undertaking to take out the 2010 Stadia issue out of the discussion.
Yes.
Isn't that what they're basing it on?
Yes. It is at paragraph 73, Justice Mlambo. They say, yeah. I submit that it is clear from the factual background set out above that the Commission expressly undertook in October 2010 not to pursue a referral and penalties against Group 5 in respect of the World Cup Stadia. In so doing, it granted Group 5 immunity. So that's the argument they make. So you are right on that issue, that what they are saying is, we thought we were engaging with you in good faith, we would get immunity. We are not getting immunity.
But they also refer to a letter to this effect from the Commission.
Yes, they refer to it in their background facts. They refer to a letter from, I think it was Mr. Musala, which they quote in full. I'll find that letter.
No, you don't have to find it, as long as we agreed. You can continue with the submission,
Yes, it's at paragraph 45. Where at page 26, they say, the Commission has undertaken to remove the following projects from your client's list of implicated projects. And then D is the 2010 FIFA World Cup Stadium meeting. So that's the complaint. And for the purposes of jurisdiction, which is taken upfront, the court must accept that all of these allegations are accurate. The only question is, who has the power to deal with this matter? Now, in paragraph 73, the issue is a fight around whether or not Group 5 should have received immunity. Now, the power to grant an immunity, you will find at section 21 of the Act. And AgriWire was decided before these provisions came into operation, but this case was decided after these provisions came into operation. So you will find the section 21 functions of the Competition Commission. So 21A, 21.1 GC. The Competition Commission is responsible to grant or refuse application for leniency in terms of section 49E. You then go to that section on 49C. Then there you find an extensive provision on leniency. So it must develop a policy. It may grant leniency. So on both of these, section 21 and section 49E, the fight is about existing power, which has not been properly exercised. And that is what the Vault Fuss is about. We thought we had got leniency. You are now telling us that we must go through the fast track process. Leniency is in section 21 and in section 49E of the Act. You again do the same exercise. You look at section 62.1a. Section 62.1a makes it clear that this is a matter that must then be dealt with because it's about existing power, which must be dealt with exclusively by the Competition Tribunal. So if they have an issue that the Commission in exercise of the power under Chapter 5, because this is a Chapter 5 issue, in exercise of that power, acted incorrectly or capriciously, that is where it belongs on an exclusive basis to the Competition Tribunal. Then,
Mr. Ngokotobi, may I interrupt you there? You mentioned agri-wire. Are you distinguishing agri-wire from the present case due to these subsequent amendments? When I say subsequent, I mean subsequent to that judgment. Do you say agri-wire doesn't apply here?
no, it doesn't apply here specifically on the leniency issue because agri-wire was decided before the Act was amended to incorporate a leniency issue to expressly provide the Commission with the power to grant a leniency, to develop a policy and to grant leniency. So it cannot be authority that binds this court on an issue where the statute was not yet decided. This case was decided after these amendments came into operation. Even the SCA's judgment came after these amendments came into operation. Those amendments came in 2019. This case was decided after that. So it's clearly distinguishable.
Yeah, thank you.
And then we find the last claim at page 39 to 40, which is under paragraph 76.1. Now, this is not a claim made under the Constitution at all. The Constitution is not mentioned here, which would be a constitutional matter under section 62.2. Constitution is not mentioned at all in relation to this third claim. But what is the claim about? The claim says, 76.1, Group 5 has engaged in good faith with the Commission over a number of years and has provided it with substantial amount of information pertaining to collusive conduct in the construction industry, including in relation to the World Cup stadiums. The Commission has accepted such information from Group 5, used it to pursue complaints and settlement agreements against other construction firms, and has led Group 5 to believe that it would be protected against prosecution and penalties in exchange for its cooperation, when in fact, the Commission intended to pursue a penalty against it. This is precisely the same complaint they make under 2, which is, we thought we got an immunity, but you didn't give us an immunity. Then in 76.2, the Commission initially gave a clear and unequivocal undertaking that it would remove the World Cup Stadia from the list of implicated projects, and thus, at the very least, not to seek an administrative penalty against Group 5. Notwithstanding this, the Commission has pursued a referral and the associated penalty against Group 5. Now, 2 questions must be answered. Where does the power to pursue a referral come from? It comes from section 50 sub 1. Where does the power to pursue an administrative penalty against a party come from? That too comes from section 59 of the Act under administrative penalties. And it is a power given expressly to the Competition Tribunal because under section 59, it says the Competition Tribunal may impose an administrative penalty for a prohibited practice under section 4151 81, 84, 91, and 91A. And this is a case we know that falls under section 59(1)A because it is an administrative penalty sought in accordance with section 4(1) of the Act. And we see that clearly from the referral of the commission, which is the referral itself starts at page 65. And the notice of motion seeks an administrative penalty equal to 10% of the annual turnover of Group 5 under section 59(2). It's page 66, paragraph 3, where it says, insofar as Group 5's conduct is found to contravene section 4(1)B, Roman figure 3, and or section 4(1)B, Roman figure 1, and or section 4(1)B, Roman figure 2, an order requiring Group 5 to pay an administrative penalty equal to 10% of its turnover in terms of section 58(1)A3, read with section 59(2) of the Act. So those three provisions, five provisions mentioned in that section, all flow from the Act. And under section 59, the penalty provision, the penalty power is assigned to the Competition Tribunal. So when all is said and done, after all of this paper that has been generated in this case, you are ultimately left with three complaints. You are left with a complaint that you made a referral, which you have the power to, without a complaint, which you have the power, without a valid complaint initiation, which again you have a power to. So you improperly exercised that power. You're left with a second complaint, which is you once promised us a leniency under the corporate leniency program. We gave you information and you did not follow through. You performed a volte-face. The third one is, this is vexatious because you told us you would remove the World Cup stadiums from the implicated projects, or at the very least, you will not seek an administrative penalty against us. All of those are matters that are under chapters 2, chapter 3. Well, chapter 3 is the major provision, so it's irrelevant. Chapter 2 and chapter 5. Those are all matters that the Competition Tribunal has exclusive jurisdiction to deal with.
Mr. Nkaitobi, can I take you back to the question that was posed by my brother Majit concerning AgriWire? Because you make the correct observation that the incorporation of leniency powers has postdated AgriWire, but AgriWire has taken an interpretation of section 27(1)(c) that is more general than I think your answer suggested, because the interpretation offered is that the review jurisdiction of the tribunal is limited to circumstances where the commission takes a final substantive decision, for example, in relation to exemption proceedings or small mergers. So the question is, where do you say on an interpretation of section 27(1)(c), where do you say the Act makes specific provision for the reviews that might lie to the tribunal? Because the language of 27(1)(c) says, in terms of this Act. Now, as I understand your contention, you say, well, that is what can be read into section 62(1).
Yes.
But
yes,
tell us where we can find in the Act outside 27(1)(c) the reference to a review jurisdiction of the tribunal.
Yes, well, the express reference to the review jurisdiction is section 27(1)(c).
Yes.
And there is no restriction there to final decision. It is any decision, interlocutory or otherwise.
Well, I think AgriWire, where AgriWire interprets this is the qualification is the language that may, in terms of this Act, be referred to it. So yes. It says that language references other parts of the Act, and it then seeks to find where in the Act those references are to be found.
Yes. Well, yes, I've tried to suggest various parts in the Act where these complaints about the improper exercise of existing power may be referred to the tribunal for it to decide whether it is exercising an appeal or a review of its a review of the Competition Commission's decisions. So each and every one of these would then be capable, in fact, it says may, which is wider, would be capable of being referred to the tribunal for its decision. If you look at paragraph 17 of Agri-Wire, which is what we've criticized in our application for leave to appeal as actually being wrong, it says unlawful actions are not within the jurisdiction of the tribunal, and an unlawful referral would accordingly not be within its jurisdiction. And then it says, but whether an act by the commission is within its jurisdiction is a matter within section 62(2)(a) of the Act and is therefore not within the exclusive jurisdiction by section 62(1)(b). But that all depends on whether the power exists, but it has been improperly exercised. If the power exists, but it has been improperly exercised, then it is a question of measuring the statute as against the exercise of the power. The 3 points that are in issue in this case are the commission acted badly.
Mr. Toby, can I check with you? Your argument suggests that 62(2)(a) and (b) really can't assist the applicants in this matter because the issues, certainly in respect of the 3 complaints, fall within the powers of the commission. And then you build that argument by saying that where a power exists in law, but it's incorrectly exercised, that doesn't trigger a question of jurisdiction.
Yes.
Nor does it raise a constitutional matter. But
yes.
Surely it must be arguable that where a power has been exercised in an unlawful way,
yes,
even if it's incorrectly, that would of necessity trigger a whole debate on virus, and therefore 62(2)(a) and possibly (b) gets triggered.
I do not necessarily accept that proposition, Justice Colapen. Let me explain why. It is true that virus usually raises constitutional matters because, as Justice Davis pointed out, all public power flows from the Constitution. But what we are engaged with here is a narrower species. The Act doesn't say virus, it just says any constitutional matter arising in terms of this Act. And it does so against the backdrop that the tribunal has exclusive jurisdiction where it has jurisdiction. So my point of departure is if you find that these questions fall within the jurisdiction of the High Court, automatically they are excluded from the jurisdiction of the Competition Tribunal. The tribunal can never deal with them because its jurisdiction is either exclusive or it does not exist at all. And that is why the starting point is to analyze whether each of the 3 complaints are matters that are within scope of the tribunal. And if they are, then they have to be dealt with exclusively by the tribunal. The question as to other forms of virus that do not arise from the Act. So I made the example of a virus that may be clearly outside of the provisions of the Act, like a divorce case. It depends whether or not that issue gives rise to a constitutional matter before it can be said that it is outside the scope of the tribunal. And so that goes into my second line of argument. And I hope I've now made the first line of argument, which is the law says you must properly interpret the pleadings. Once you properly interpret these pleadings, it's clear that all of the issues they give rise to matters where the commission has the power, but where the complaint is that the power has been improperly exercised. All of those questions are within the jurisdiction of the tribunal by virtue of section 27(1)(c) of the Act. The next question is the second, the paragraph 56 of the, and this comes from the judgment of this court in paragraph 56 of Gaba, where the legislature creates a specialist body. It is said that it is required by law that that specialist body and its mechanisms must be followed. Let me read out paragraph 56 on the relevant part. It says, however, another principle or policy consideration is that the Constitution recognizes the need for specificity and specialization in a modern and complex society under the rule of law. Therefore, a wide range of rights and their respective areas of law in which they apply are explicitly recognized in the Constitution. Then they say different kinds of relationships between citizens and the state and citizens among each other are dealt with in different provisions. The legislature is sometimes specifically mandated to create detailed legislation for a particular area. Once a set of carefully crafted rules and structures has been created for the effective and speedy resolutions of disputes and protection of rights in a particular area of law, it is preferable to use that particular system. So the second ground on which I argue my case is to say, firstly—
Can I just ask you this question then, that you say it's preferable to use that mechanism, and in paragraph 3 of your heads, you also say that on questions of practicality and pragmatism, we should overturn the SCA decision as well as on the question of legal principle. But is the question not simply this, Mr. Ngagatobi, that the question of whether the court has jurisdiction or not, having regard to 62(2), is not a question of practicality or pragmatism? It either is jurisdiction that is given by the legislature, and even if that's undesirable in terms of creating two separate structures, one a specialist one and the other one a high court one that would share jurisdiction, then it is what it is. And how far can this court go if indeed it concludes that that was what the legislature has said and what the legislature has intended?
No, the court must give an interpretation of where is the dividing line to be drawn. When it is giving that interpretation, it is using various tools of analysis. One of those tools of analysis is the constitutional principle that recognizes specialization, which is embedded in the Constitution itself. So at the stage at which we are drawing where the line is, in other words, is there jurisdiction or not? It's clear that once jurisdiction exists, there's nothing you can do. But we are at the stage before that decision is to be made. In other words, is there jurisdiction or is there no jurisdiction? On that score, one of the tools you will draw from is the principle of specialization, which you have already ruled is embedded in our Constitution, specifically in the modern economic society. So that's the argument I am advancing here. So if you look at the Competition Act, you have to ask yourself whether the legislative purpose that is apparent from that act is one that moves towards specialization or not. And once you unpack that principle, it is an interpretative guide that will channel you towards the outcome that we are trying to suggest. So my first argument was squarely on the words and the context of section 62 by reference to the balance of the act. My second point is the purpose.
Before the second point, we are 1 minute over your 45 minutes or beyond your 45 minutes. How much more time do you want?
I think I can finish this in 10 minutes, Justice Madlang.
10 minutes.
That will be acceptable.
That's certainly acceptable.
Yes.
Thank you, Mr. Secretary.
Now, let me develop then the principle of specialization, which I say is a second basis on which you should, in your reasoning, find for us. I've shown the court where it appears from the Gaba principle. One leg of the analysis is to look at the substantive provisions of the Act. These you will find in Chapter 2 and Chapter 3. Basically, what this Act is about is 3 substantive provisions. The one is the regulation of cartel behavior through investigation and prosecution. The second is the regulation of abuse of a dominant position by firms in a market. The third is what is called measure control. Those are the 3 substantive provisions. All of these 3 substantive provisions, cartel prosecution and investigation, abuse of dominant positions, or measure control, are connected by law and economics. Unlike any other judgment any other sphere of the law, what this is about the application of law on economic relationships. So you take cartels. The first question you have to answer in a cartel prosecution is whether the parties are in a horizontal relationship. Now, unraveling that question always requires an economic analysis of the relationship between the parties or between the firms. The same applies to even the definition of a firm. Even that definition of a firm engages an economic analysis. The same position applies where one is trying to work out if a firm is in a dominant position or whether it has abused its dominance. The underlying factual substratum is economic analysis. Again, on the third leg of what the substantive provisions are, which is measures, that world, as the court has recently recognized in Mediclinic, is about the economic relationships and the implications those may have on competition as well as consumers. So the Act sets out an area of specialization and expertise which operates on the basis of a combination of law and economics, where the substratum is economics and law is applied on those economic relationships. But in addition to that, the Act recognizes that it needs specialist bodies in order to regulate and apply the law on these economic relationships. In Section 28, it sets up the qualification of the members of the tribunal. And uniquely, members of the tribunal, one of the requirements is economics. And it is not surprising that economics is also a factor to be taken into account. The same applies to Section 31 of the Act. Section 31 of the Act in relation to competition tribunal proceedings. At least one member of the panel must have legal training and expertise, even though 3 members of the panel must sit. So at every turn, when you read what the Act is about and what are the dispute resolution structures that have been chosen by the Act, what you find is the distinctive feature that you are dealing with the application of law to a given set of economic relationships, which is why you have recently decided in the case of Mediclinic that you should defer to the judgment of the tribunal. You have elevated the role of the tribunal because the tribunal is a specialist body and because the tribunal operates by a combination of these skills of economics and law combined. That is a very powerful indication that the line in Gaba, paragraph 56, where the legislature has chosen a specialist forum to resolve specific types of cases, that forum ought to be utilized. And that is why you will have to be very slow in coming to the conclusion that a mere label to a dispute, because in this dispute, you will see the label legality and the label rule of law and the label section 1C, never unpacked about what its substantive content is. A mere label should not detract the court from undertaking the real substantive analysis, which is to say, these cases that I'm engaged with, are these the sort of cases that we had in mind in Gaba or not? And it's quite clear that the entire scheme of the legislature is that the Competition Tribunal should exercise exclusive jurisdiction when it comes to specific types of cases. Now, these three complaints fall precisely under the sort of run-on-the-mill cases that the tribunal deals with every day.
Mr. Ngugaitobe, excuse me. Coming back to the label or characterization of the claims, taking into account the three claims that you have correctly identified as being ones that were asserted by the respondent. The only indication, correct me if I'm right, about the virus as well as the legality point arises, I think it's paragraph 73, if I'm right. And I just want to ascertain from you whether any flesh has been given in the pleadings to the two aspects, or the two aspects, that is the legality as well as the virus claim. And secondly, when the complaint secondly, when you look at the pleadings, right, what would you be identifying the claim to be based upon? Would it be clear from the pleadings itself that one is talking about the virus, the legality, or the three claims that we've identified, the referral, the leniency, as well as the vexatious proceedings? I just want to be clarified on that.
Yes, you are right, Justice Matopo. The ultra-virus as a term appears once in the pleadings. And then you have the notice of motion that speaks of Paja. And I think there's somewhere where I saw it says in the alternative legality. But there is never anywhere where any substantive content is given to what exactly about legality. Instead, these are all Paja claims. And there is never anywhere that it sets out what exactly is the complaint about ultra-virus. Now, this is unlike the case you dealt with recently of Baloy, where the constitutional claim was identified specifically by a provision in the Constitution that the criticism against the public protector was that she had abused the powers in Section 182 of the Constitution. And that is why her conduct was being challenged as being unconstitutional. So if you run a case like this, which for all intents and purposes is a case that should go to the tribunal, and you try to get out of that by a mere label, we ask the court not to endorse that approach. You will see this is something unique because in the ruling of the SCA, there is also no analysis of the pleadings. In paragraph 27, it is just asserted, you will see this at page 468. It is just asserted that the issues raised on review are not of a specialist nature. And the last time you checked what these issues raised was in the introduction, where the summary of the claims was set out, which was at page 459, paragraph 8. But thereafter, there is no analysis, which this court says, whenever you are confronted with a jurisdictional question taken upfront, you must undertake an analysis of the pleadings in order to properly construe them to work out what claim in substance is being pursued. So the short answer to that question is there is no unpacking of this legality or ultra-virus argument. It's put in one paragraph and then it's moving. That is why when you look, each time they complain, they're complaining about matters where there is power, but they are saying it's not been properly exercised or used, and but we say that is the matter. There is a last point to be made on this. I've made the case in favor of specialization, but there is a related point which you've already alluded to as the court in the Standard Bank case, which is expedition. The problem we are facing right now in this case is that we are 12 years down the line. Whenever the commission institutes a proceeding and it is challenged in a collateral proceedings, the commission stops because it cannot continue the prosecution until the review has been disposed of. But this is precisely the issue that Justice Jafta and Justice Khampempe in the majority judgment in the Standard Bank case spoke about. That when you interpret the act, you have to do it in a way that does not shackle the commission from enforcement. If you look at this case, 4 of the parties, I've referred to these parties from paragraph 41 of the papers, who have admitted liability, have paid because they've rigged the bids. We have one party which on its own account says they were also involved in the rigging, but they cannot be prosecuted because one is waiting for this review. So a strong factor that you will take into account in your analysis about where the line ought to be drawn is the risk for enforcement of the act. And that is why we say, for those 3 reasons, we ask that you should overturn the judgment of the SCA and you should come to the conclusion that in this case, there was no jurisdiction of the High Court properly invoked. Thank you, Justice Madlang.
Thank you, Mr. Mqetobi. Yes, Mr. Bana.
Thank you, Justice. Justice, what we propose to do, time permitting, is firstly to deal with the issue of the pleaded case. We say, while Section 27 is an interesting debate, and we notice our learned friend, although spending much time in the heads of argument on this point, has not really dealt with that squarely in argument. The core issue, we say, is whether the review is one that triggers Section 62(1)(a), if it's a jurisdictional challenge, or 62(2)(b), if it's a constitutional matter. And if that is the case, then either under the carve-out under 62(1) or under 62(2) proper, it's clear that there can be no exclusive jurisdiction of the Competition Tribunal. And it's interesting that in response to a very pertinent question by Justice Unterhalter as to where the power of the tribunal is to be found, our learned friend really skirted that issue and didn't answer it. The question was, where in the Act, outside Section 27(1)(c), is the tribunal's power to review to be found? And it's a question that our learned friend skirted completely. So our submissions are that once we demonstrate that this is a 62(2)(a) or 62(2)(b) type of case, i.e. either a jurisdictional challenge as envisaged there or a constitutional challenge, one is outside the realm of exclusive jurisdiction. And that really is the end of the matter. Now, we, in passing, make this point, and we have no difficulty in dealing with the pleadings, and we will take you to them, but it's also resubmit in a review matter where the pleadings are clearly in a state of flux until the record is produced, and one which this court and the SCA has said ought to be judged not at the stage at which the case is first brought because the pleadings are incomplete and will ultimately be supplemented. We say it is somewhat premature to judge the case on an incomplete set of pleadings where the record, when it is produced, will result in a supplementation of the founding affidavit and in the supplementation of the grounds of review. But having said that, we have no difficulty, even on the basis that has been set out on the incomplete case as it is, because the record hasn't been furnished and there hasn't been a supplementation to demonstrate that this is squarely a 62, this is both a 62(2)(a) and a 62(2)(b) type of case. And we say broadly, and we'll come back to this, the approach taken by our learned friends is really one that firstly is one based in semantics, and that is asking whether the case, the ultra vires challenge, deals with a case which says that you don't have a power at all, in other words, an absolute or pure ultra vires, or one which, as we say, there may be a power in the act, but if that power is not the power that's exercised, we say you are exercising a non-existent power. So it's really semantics to deal with the matter in which our learned friend does, and we say that gets you nowhere. But the question will always come back to the carve-out in 62(1), and that is the carve-out that says where it's a 62(2) type matter, there is no exclusive jurisdiction. And we submit that's a hurdle the Commission can never overcome, because issues of vires classically are issues that deal with the jurisdiction of both the Commission and the Tribunal, and issues based on a legality challenge are classically constitutional matters, and that is completely non-controversial. So we say that the Commission has to persuade you that the so-called bio-watch principle that was referred to by the SCA is of no application, and also has to persuade you at the level of principle that agri-wire is incorrect. And it is no answer to deal with the issue as our learned friend does, because as suggested by Justice Interhalter, what the SCA was dealing with there was the issue of principle and the interpretation of Section 27(1)(c) and Section 62, and none of that changed with any of the amendments. But we say, very interestingly, the Commission really brings a case to you which is internally destructive and contradictory, because to get through the gates, it tells you in its application that the application concerns a constitutional issue. But in the same breath, it wishes to argue that the review doesn't raise a constitutional issue. And we say that is not a matter which you will countenance, and it is a contradiction which you will see through. The vires and jurisdiction challenge clearly is rooted in Paja, and it is not so that there's just a mention in one phrase of the phrase vires. As our learned friend says, ultimately the label is neither here nor there, but the phrase vires is used in several places throughout the application in the review, and in any event, even without that phrase, when one has regard to the substance of the challenge raised on jurisdiction, it is one clearly which goes to vires. And it's necessary to emphasize that the objection is not just to the jurisdiction of the Commission to investigate, because if there's an invalid referral, that goes directly to the jurisdiction of the Tribunal as well. So what our learned friends would want to have here is, on an imperfect demonstration of where the Tribunal has a broad review power, and we say it doesn't, it wants the Tribunal to sit in consideration of that very issue where there's a challenge even to the jurisdiction of the Tribunal because of the impermissible referral. We say clearly the application also involves the a constitutional issue, because the issue of legality is squarely raised, and this was identified by the Supreme Court of Appeal in 2 paragraphs of the judgment, which are worth having quick regard to. And we say that clearly the Commission doesn't get out of that starting block or that hurdle. And the 2 paragraphs are paragraph 23 of the judgment, which is to be found in the record at page 466. Where the court, dealing with Section 62 and Section 27, said the following: unlawful actions are not within its jurisdiction, and an unlawful referral would accordingly not be within its jurisdiction. But whether an act by the Commission is within its jurisdiction is a matter within 62(2)(a) of the Act, and is therefore not within the exclusive jurisdiction conferred by 62(1)(b). And then in paragraph 24, the issue of legality is dealt with, and the SCA stated a question whether a referral by the Commission is valid or unlawful, or whether the Commission acted beyond the scope of the Act, and accordingly ultra vires the powers conferred on it, is a jurisdictional question, which falls within the purview of 62(2)(a) as stated in Agri-Wire. The legality of a public body's conduct is also a constitutional matter, and references in 62(2)(b). And the Constitutional Court has repeatedly said so in relation to the Biowatch principle, and then referring to the Justice Alliance case in that paragraph, in the quotation there was that the attack on the validity of the guidelines as being ultra vires, section 137 of the Act, is based on the principle of legality. And clearly, legality is decidedly a constitutional issue. And then the reference in paragraph 25 to the Haralal matter, where it was held that the constitutional issue raised by the case are twofold. First, a review of administrative action under PAJA constitutes a constitutional issue. This is so because PAJA was passed specifically to give effect to administrative justice rights guaranteed by Section 33 of the Constitution. Moreover, when universally determined the application for admission, it exercised a public power. According to jurisprudence of this court, the review of the exercise of public power is now controlled by the Constitution and legislation enacted to give effect to it. It is not controversial that a review of administrative action amounts to a constitutional issue. And once that is accepted, the semantics around whether the case here is one where the applicant in the review, that is Group 5, stated that there was a power, but that power was not exercised, or there's a non-existent power, in substance really makes little difference. We say it is clear that even though a power may exist on the statute book in the Act, if that power is not exercised or is exercised unlawfully, there is a non-exercise of a statutorily recognized power. And
Mr. Bana, at that point, the 10 minutes is up.
Thank you, Justice.
Mr.
Yeah.
Bana, can we look at section 62, please?
Yes.
In particular, 62(1)(a),
Yes.
which says that the Competition Tribunal and the CAC share exclusive jurisdiction in respect of the following matters: A, interpretation and application of chapters 2, 3, and 5. I'll pause there for now. I'm more interested in chapter 5, which we know that includes that chapter concerns the investigation and adjudication procedures. And this will include the protection of confidential information mediated by the tribunal, initiation of a complaint, the granting of leniency by the commission, the referral of a complaint by a commission. Now, what I would like to know is, we know in this case that the commission referred the 4 companies, including Group 5, to the tribunal. And there's a complaint by the Group 5 that, in fact, the commission had granted it leniency, and it should not have referred it to the tribunal. What I'd like to know is, where one has a complaint like that, why is it necessary for the person to then go outside the parameters of the Competition Act and then say the action is unlawful? Are there no other means for that particular party to complain within the institutions that are designed to deal with competition law matters?
So we want to deal with the submission firstly by making this point. The fact that it might raise or identify a power that is set out in chapter 5 is not sufficient to bring the commission within 62(1), because what is critical is the carve-out, which says interpretation and application of chapters 2, 3, and 5, other than a question or matter referred to in subsection 2. So the starting point is whether this is a subsection 2 matter. In other words, as we've said, the two sections we point to are whether an action taken or proposed to be taken by the Commission or the Tribunal is within their respective jurisdictions, or whether there's a constitutional matter. And once that is appreciated and regard is had to that, it doesn't matter that the specific power or the non-exercise of the power is one that is referred to in Chapter 5 or elsewhere. The question is whether you come within the carve-out. On the second point, as I understand it, is whether if there is a forum that can deal with this, whether that is determinative of the matter. And in a sense, this touches on our learned friend second leg, and that is that because there's a specialist forum here, one has to defer to that. And we say on application of the principles of this court in Beloy, and including which relied on the Richards Bay case, the fact that there may be some other specialist tribunal does not deprive a court of concurrent jurisdiction. So if the High Court has concurrent jurisdiction with the CAC, and we emphasize that because we say there is no general review power of the tribunal, even if there is concurrent jurisdiction with the CAC, that does not compel a party to go to the CAC merely because it concerns some question or section in a Competition Act. Because notoriously, high courts are equally able to decide issues of vires and the interpretation of a statute. There's no specialist economic knowledge that comes into that. But even if that were so, it doesn't, in principle, defeat the fact that there's a choice if you're in a 62-2 world between the Competition Appeal Court and the High Court. But that does not mean one is compelled to go to the tribunal, as our learned friends seek to argue.
The 62-2 point that you make, when if we go there, the question whether an action taken or proposed to be taken by the Competition Commission or Tribunal that is now the question of jurisdiction. What was the action here that was outside of the jurisdiction of the tribunal?
The action that was taken was the initiation of what was an investigation before there had been a proper initiation. The classic Woodlands defect, which the SCA found, that the Commission can only exercise any of the powers if there is a valid initiation. And this is identified in the pleadings, and that is this whole exercise that was conducted before the initiation is the fact that there was not a proper initiation, and therefore the Commission didn't have any of the powers it purports to exercise. So once again, that's an example. Even though notionally there may be a power in the statute, one has to bring yourself within the proper jurisdictional requisites for the exercise of that power. And where the Commission here didn't do so, it actually acted without a power. There's no difference there with a classic pure ultra vires, as was put in debate to our learned friends, and one where there is a power, but the requisites for the exercise of that power were not satisfied.
Mr. Bonner, if my sister Justice McClung, thank you. While we're on section 62(2)(b), how would you say that that section can be reconciled with section 27(1)(c)?
We say it's a fairly easy matter to do. Firstly, again, at the cost of repeating the point, 62(2) deals with the power of the Competition Appeal Court. So if you're in a concurrent jurisdiction world, that's the High Court with the CAC. It is not High Court with the Tribunal. Then dealing with 27(1), with section 27(1)(c), the point that we make in our heads of argument and the answer to what you put to us, Justice Theron, is that there's no general review power given to the Tribunal. 27(1)(c) must be read in its complete form. So whilst it refers to appeals or reviews of the Commission, it goes on to say that may, in terms of this Act, be referred to it. So it's a bounded, if you want, review power, not an unbounded general review power. It's another reason why you couldn't bring a PAJA review based on section 27(1)(c) to the tribunal. Firstly, because PAJA in section 6 and with the definition of the court makes clear that it's got to be a high court or a court of similar status. But secondly, the general review power is not one that can be found anywhere in the Act. And that was the question Justice Unterhalter put to our learned friend, which he couldn't answer. In that regard, the table that, firstly, we want to make this point, you contrast section 27 with section 37, which except for interlocutory applications, doesn't have those words, may in terms of this Act be referred to it. So unlike the Competition Tribunal, the Competition Appeal Court's power is not bounded by those words which may in terms of this Act be referred to it. Having regard to the wording of section 37, you'll see that reads the appeal court, the CAC may review any decision of the Competition Tribunal. What's missing are those words, may in terms of this Act be referred, and then consider an appeal from any final decision. Again, what's missing are those words that may in terms of this Act be referred, and then only in interlocutory decisions, those words appear that may in terms of this Act be taken. So regard has to be given to those words, which is a very conscious choice by the legislature. And it's a very conscious choice where the legislature intends to limit or restrict the appeal or review power. Those words are used in relation to all of the tribunal's so-called appeal or review powers as set out in 27(1)(c). And in interpreting that, you'll contrast it with section 37. It's for this reason also that we believe the table that we produced and which we hope has found its way to you, justices, demonstrates which kinds of matters can be brought on appeal or review to the tribunal. And
Mr. Bonner, I'm sorry, before we go to the table, your response to my question regarding section 27(1)(c) and 62(2)(b), does that not in some way render the tribunal's review jurisdiction nugatory?
Can I ask you just to clarify that for me, Justice Theron? In what respect do you have in mind?
Yes. Well, won't it impact also on the question of exclusive jurisdiction? And isn't that something also dealt with in the SCA's judgment regarding the review jurisdiction of the tribunal?
So let's assume that the Commission can bring itself within a 27(1)(c) world, as we say, where it's got to show you not just that it's an appeal or review, but it's got to point to some other provision of the Act which allows it to bring the appeal or review to the tribunal. You will always come back to the caveat in 62(1), where once again the caveat is that even though it may involve an interpretation or application of chapters 2, 3, and 5, and we assume for the purposes of your question that the Commission can show that this kind of decision is reviewable in terms of the Act, that you can't ignore the caveat, the very critical caveat in 62(1) itself, and that is it must not be a 62(2) type question. I'm not sure if that answers the question.
Thank you, Mr. Bonner.
Sorry, Mr. Bonner, can I come in here as well? And if the idea behind 62 was to create, on the one hand, exclusive jurisdiction, and that's what 62(1) does, and then in 62(2) to create concurrent jurisdiction, then on your argument, if indeed 62(1)(a) was intended to give the tribunal exclusive jurisdiction in respect of the interpretation and application of chapters 2, 3, and 5, then in a practical way, that exclusive jurisdiction would not exist if we give 62(2) the meaning you contend for, because virtually every review of every power in terms of 2, 3, and 5 would trigger on your argument, and indeed the SCA's argument, the concurrent jurisdiction of the High Court. And should we not interpret 62, and in particular the relationship between 1 and 2, to give proper effect to the intention of the legislature, that it was intended to create a tribunal with exclusive jurisdiction, and in respect of certain limited matters, concurrent jurisdiction. But on what is before us, it would appear that there would simply be no exclusive jurisdiction. And is the answer not to give jurisdiction in 62 to a limited interpretation in order to make 62(1)(a) meaningful?
I can't think of an example offhand, but one may occur to me shortly. But we say there clearly could be instances where it's not correct that by applying it as we suggest is the only way to apply it, you would render 62(1) nugatory. Let's assume it's purely an issue of a review of a commission's decision on a small merger. That clearly is a 62(1), and you could never argue there that you're in the realm of a 62(2). So that is one example.
Except Mr. Bana, on your earlier argument, you indicated that if the commission doesn't have a power, or if it has the power and the power is incorrectly exercised, that would be it. That would be a question of jurisdiction. So even on the merger argument, I can't imagine on what basis there would be a review that would not implicate either the existence of a power or the correct exercise of that power. And that would trigger the concurrent jurisdiction.
Yes, let's assume on the facts, the commission finds that a small merger raises issues of substantial lessening of competition. That is such an example where that's a review which would easily be brought to the tribunal, because it's not an issue of the powers of the commission. It's simply that the commission is incorrect on the facts. And they can be.
And if it's incorrect on the facts, then it misconceives its powers, doesn't it?
Well, what you do touch on is this debate on a broad on the issue of a broad constitutional matter and a narrow constitutional matter. But we say, whilst there are such issues, and in the cases where it said an application to compel further particulars may be a constitutional matter, we're not dealing with that kind of extremely broad or remote constitutional challenge. The challenge here goes directly to vires and legality. And even on the narrow reading of constitutional matter, even on the narrow interpretation, we are within that narrow interpretation. It's not a fight on discovery or further particulars or that kind of issue where the courts have said, well, any issue can be regarded broadly as a constitutional issue. We're not in that very broad realm here. So we say that when you have regard to the pleadings, and indeed you should have regard to the pleadings, but our learned friends where they simply say, well, it's not, this is not a constitutional issue or a jurisdiction issue because you're really pointing to a power that's in the act. We say that's entirely misleading and an entirely improper question as to whether the issue of jurisdiction and legality is raised as a 62(2) issue. We say the further difficulty and great difficulty for the commission is that it's got to demonstrate an ouster of the High Court's jurisdiction. Without laboring the point, we know from the Tobayani matter that that is a very difficult threshold to meet, and we say one here that the commission just doesn't demonstrate. So before you find that there's an ouster, our learned friends have to satisfy you on the basis of Tobayani and the decisions that it relied on, including Richards Bay, of at least the following factors, or you've got to have regard to the following. Firstly, the very strong presumption against ouster of the High Court's jurisdiction. Secondly, the mere fact that the statute vests jurisdiction in one court, one tribunal, is insufficient to create an implication that the jurisdiction of another court is thereby ousted. The courts have also said that threshold is very high. and there's either got to be an express ouster of the High Court's jurisdiction or one that is necessary implicitly.
Mr. Bonner, I wonder if I could interrupt you there, because I think various members of the court are trying to probe what the content of 62.1 is. And it does seem to be a difficult provision. Perhaps we could just look briefly at 62.1b, because that enumerates the powers or references the powers of the Commission, the Tribunal, and the Competition Appeal Court. Now, since those institutions enjoy the powers that are referenced in those sections, what is the point of saying that the Competition Appeal Court enjoys exclusive jurisdiction over the exercise of its own powers, which have already been granted to it under Section 37? And similarly with the Tribunal and similarly with the Commission. We've got to try and give some meaning to 62, which isn't simply repeating the powers that have already been conferred on these institutions. So, I mean, is it not that what this provision is intended to connote is that other courts can't give or don't have jurisdiction to interpret the exercise of these powers, that there is a kind of immunity that is enjoyed by these institutions in respect of the enjoyment and exercise of their powers?
Can we approach that issue by saying if that were the approach, then 62.2 would be redundant?
Well, you see, we keep going between the two. How big or how small is the one provision versus the other? But what might be possible is that 62.2 is a carve-out, as you've correctly said, but it is in respect of a narrower sense of ultra vires. So for example, you couldn't go to the High Court to ask the High Court to give a declaratory order as to the meaning of Section 4.1b, when it's for the Tribunal and the Competition Appeal Court to decide what that provision means and how it's to be of application.
Yes, then you would squarely be in a 62.1 without.
Yes, and that's what I'm trying to ask you about, which is, how can one give substance to 62.1 to give some institutional integrity to and exclusivity to these institutions without reading down completely the carve-out in 62.2 and vice versa?
Yes, I think that is the point we're trying to make, that even on a narrow reading of 62.2, this case would not be one where you would find that you're in the exclusive jurisdiction of the Tribunal, because it would not be the kind of example given where one is dealing with an interpretation of Section 4. But can we perhaps also answer the question in this way, and having drawn or having raised 62.1a sub 3, the issue subsection B, the reference to 27.1, one would always go back to 27.1 and say, where do you find to be within a 62.1, even on a narrow reading of constitutional issue or jurisdiction? Where do you find the power in 27.1 for general reviews or paja reviews? And we say you don't find it there. So even on that reading, it says that you've got to read 62.2 narrowly, constitutional narrowly there. You will always have to read these sections together. When you read 62.1 with 27, you are unable to find a general review or appeal power other than those that we've identified in the table for you. I'm not sure if that's of some assistance.
Thank you.
Mr. Halter. We then, I just want to pick up my thread. Yes, just to finish the ouster point and the one point remaining on that, if I may, from Tobayani, and dealing with the Richards Bay case, the test for inferring ouster, the court said a court's jurisdiction is excluded only if that conclusion flows by necessary implication, and then only to the extent indicated by such necessary implication. And I suppose that also touches on what you've just put to me, Justice Unterholter. And the court in Tobayani went on to emphasize, in this regard, it's not enough to show that a specialist court enjoys powers of review similar to those exercised by the High Court. The party must go further and show that the legislature intended such power to be exclusive. And we say generally in terms of amendments and timing of amendments, when the Competition Act was amended in 2018, the court, the legislature would have been aware of Agri-Wire and could have been aware of all of the other dicta of the courts in Mondi and so on. And notwithstanding that, it did not choose to expressly oust the jurisdiction of the High Court. And therefore, when our learned friend says that you don't anywhere find in this act find a concurrent jurisdiction section, that's not correct, because section 62.2 read intelligently in the only way that it can be suggests that what one is dealing with there, when it says in addition to any other jurisdiction, the Competition Appeal Court, in this act to the Competition Appeal Court, the court has jurisdiction over those matters. What it's dealing with there is an additional jurisdiction, not one that is in the realm of its exclusive jurisdiction. And when one appreciates that, it's clear that 62.2 is dealing with a concurrency issue. And the word concurrent doesn't have to be used, but when you in one section deal with exclusive jurisdiction and then in the next section deal with other powers, it's clear those powers are powers that another tribunal or forum may have, and you then saying that the Competition Appeal Court also has that. So it's the intelligent reading of 62.2 is that it's a cumulative power. One, I think it's used in Agri-Wire or Tobayani, that it's a cumulative power, and therefore one is dealing with concurrent jurisdiction. So on that score, we say that the Commission doesn't come close to getting over the hurdle to show that there's an ouster of the jurisdiction of the High Court. We then wish to just deal with the issue on the contradiction of the Commission's case, and if I can try that. The point that we made in opening, that there's an inherent contradiction. So firstly, you will read in the record, volume 5, page 422, that in order to get through the gates, to get the attention of the Constitutional Court, our learned friends say that the application raises a constitutional issue. It says so in paragraph 17 of its application. And it says, I'm advised and accordingly submit that the matter is plainly within the jurisdiction of this court. It is squarely a constitutional matter. It is about the jurisdiction afforded to adjudicative bodies and relies on all of those decisions, Yara, Pickford, and so on. And then in the very same breath, the Commission seeks to argue that Group 5's review doesn't raise a constitutional issue as contemplated by 62.2b. And we say that this is an inherent contradiction. In paragraph 60 of its founding affidavit, record volume 5, page 441, it said the following: in any event, for the reasons canvassed below, the SCA erred in determining a review to be a constitutional matter which ousts the exclusive jurisdiction of the court. And then at volume 5, page 444, paragraphs 67, 68, and 69, they deal with the issue of a legality review falling within the narrow meaning of the constitution of a constitutional matter. But we say that the Commission cannot, on the one hand, to get to obtaining leave to appeal from you, suggest that there's a constitutional issue involved, and at the same time suggest to you that there is no constitutional issue in the review. But taken to its logical conclusion, it's interesting to see what the Commission says.
Just on that, Mr. Pana, you'd surely not suggest that this matter does not raise a constitutional issue, would you?
No, we say clearly that it raises as much of a constitutional issue as the review raises.
I'm raising that purely to see how far does the point you are making now take you, because one could couch the point made by the applicant another way. The question whether this raises a constitutional issue for purposes of the virus or jurisdictional point raised by the respondent, that is whether that raises a constitutional issue. It doesn't really take us far, but well, you are counsel, and I guess as counsel you are entitled to raise the contradictory point, but I'm not sure how far it takes us for purposes of the determination of the matter.
Where it takes us, Justice Badlanga, is that we say that there's somewhat of an intellectual dishonesty there to try and suggest that the review doesn't raise a constitutional issue, but there's clearly a constitutional issue involved in the matter, and that's why leave should be granted. And we say the intellectually honest approach is to accept that the application itself for leave raises a constitutional issue, as does the review, Group 5's review. And it's perhaps useful to take you to paragraph 69, which rounds off what the Commission submits to you in its application. Paragraph 69, record volume 5, pages 444, and I think it carries over into 445, where they say the SCA's judgment muddles any meaningful line. It permits a respondent to frustrate and delay referrals before the tribunal. It provides for extensive appeal process of a review application up to the Constitutional Court in circumstances where the CAC ought to be the final arbiter of these issues. Now, what are they really suggesting here? And by the way, on the issue of delay, this is not a matter where there was a strategy of delay. The delay firstly arose because the Commission took more than 5 years with its referral after the initiation, and then delayed in terms of saying to Group 5, we will give you documents, and those documents were forthcoming, and there were applications to compel. But be that as it may, at its logical conclusion, what they're suggesting is that because there would be a delay by virtue of an appeal, of a further appeal, these matters must stop at the level of the CAC. But again, we say, taken to its logical conclusion, that would mean that the Constitutional Court itself may not end up sitting in consideration of these matters. And because that's really the only level that cuts out, whether you bring your review before the tribunal for argument's sake or the High Court. If it's a High Court review, the appeal is to the SCA and then the Concourt. And if it's an appeal, as they say, the appeal stops at the court. So really, what does this cut out? It cuts out one level of appeal, and the level that it cuts out, this approach that's also tied up to the policy argument, is the appeal to the Constitutional Court. And we
may I find this out, Mr. Bana? Framed as it is, does the virus point involve the interpretation of the Competition Act at all, or not?
No, we say it doesn't involve any interpretation of the Competition Act. No more than when you deal with any virus point before in a review court, whether it arises in terms of the NERSA Act. And I argued the point once before Justice Collopin for NERSA, where it was rejected, and the court correctly said that in looking at issues of virus, is simply look at the statute, and it's not involving the kind of interpretation that requires any specialist.
I'm not sure that I follow that argument, because when you look at the statute, what do you look at it for other than to understand what it says? And once you do that, what exactly does the statute mean? What does it say? And then from there you move to whether or not the power exists or does not exist. Does that not at some level involve interpretation? I don't follow the point you've just made.
I understand the proposition you're putting to me now. In any consideration of vires or otherwise would involve an interpretation of the section, but our submission is that that interpretation doesn't require any specialist knowledge. Courts all the time interpret legislation in special pieces of legislation, whether it's the Competition Act or any of the other acts. That doesn't require any specialist knowledge to interpret.
May I ask another question related, of course? Say the question was, on a proper interpretation of the Act, was this referral made properly? Would the tribunal have jurisdiction to consider that? On a proper interpretation of the Act, was this referral made properly?
We say no, because our learned friends have to show that this is that is a 27(1)(c) type of review. And they have to, that is why, with respect, the question by Justice Untitled was such a critical question. They would have to show where, in terms of the Act, other than 27(1)(c), that general review power is to be found. So we say that that is not a matter for the tribunal. You don't come within 27(1)(c), and therefore you don't even get to section 62(1). Because that review power has to be found somewhere in the Act other than section 27.
But why does that not fall under 27(1)(c)?
Because
the question that I've posed, why does it not fall under 27(1)(c)?
Because of the words, Justice, that say that in terms of the Act may be referred to it. And we say you've got to look at other provisions of the Act to see which appeals and reviews can be referred. And that is why we've gone through the trouble of creating that table, which is in table 2, to deal with provisions of the Act which provide for a review or appeal to the Competition Tribunal. And you'll see, having regard to the sections, there are numerous other sections which deal with the tribunal sitting in appeal or in review of a decision of the Commission. And that is where the power has to be found in terms, not just in 27(1)(c), but you've got to look at the other sections of the Act which allow you to or don't allow you to review. So, for example, section 44(5) and 6, dealing with the issue of confidential information, provides for that, for an aggrieved party to refer that decision to the tribunal. That is a review of the Commission's decision to the tribunal. Then dealing with appeal, section 10(8) is the exemption issue, and where the Competition Commission, where there's an application for exemption, various parties are given a right to bring an appeal against the Commission's decision to the tribunal. So again, there's another substantive section which provides for the appeal. And so, for example, 43B and all of the other sections that we set out in table 2. And you will not find in those, you will not find any other section which provides for a general review of this type of matter in the Act.
Thank you. Mr. Bana, we are 2 minutes beyond your time. Of course, I'm to blame because of my engagement. How much more time do you want?
I think I'm fairly close to finishing. I just want to firstly say in relation, we say that because
just so that we are not in the dark, just give what you think is enough for you to finish your submission.
I think 5 to 10 minutes, Justice.
Let's say 10 minutes then, Mr. Bana. All right, please continue.
Mr. Bana, let me just come in here. I just want to understand from your own perspective, what do you regard the ambit of the review power of the tribunal is, as set out in 27(1)(c. And let's take the debate you've had with Justice Matlanga. One of your complaints is that your client was granted immunity. Now, the commission is the one that grants immunity in terms of this act. Doesn't that exercise involve an interpretation of this act? And doesn't it fall under 27(1)(c)? If there's a complaint whether immunity was granted or not.
May I deal with the question in two ways? Firstly, 27(1)(c), had that been the intention, where if any interpretation of the act was one that could be brought on appeal or review to the tribunal, you would not have found the words at the end of that section which says, which may in terms of this act be referred to it. So there is no other provision, or there is no provision in the act which says that there's a review power on any interpretative exercise.
It says any. It says any, or review any decision of.
Yes, but it's then qualified, which may be referred to it. So that is the point I had made earlier of it not being an unbounded power. It doesn't stop at may appeal or review any decision of the commission. It doesn't stop there. You've got to give effect to the words that follow, and that is what limits or bounds the appeal or review power of the tribunal. So a general interpretation question, if you can't find a provision elsewhere in the act which allows you to bring an appeal or review to the tribunal, is not within the tribunal's 27(1) function.
Yeah.
But on the
Let me just ask you a different question. In terms of 62(1)(a), I just want to understand what your understanding of the phrase "other than" in A, because "other than" then refers to issues that are in subsection 2. Does it mean the tribunal has no jurisdiction whatsoever, or it has, on your argument, concurrent jurisdiction in the matters that are in subsection 2?
No, not at all. We say the only concurrent jurisdiction in 2 is with the Competition Appeal Court. Not
I see. So "other than" means it has exclusive jurisdiction on those issues in A, but if something is referred to in B, in 2, in 2, then it has no jurisdiction whatsoever. It's out.
Indeed.
Okay.
In the case of the tribunal, if it falls within sub 2, it's out. In the case of the CAC, if it falls within 2, it's within its concurrent jurisdiction.
Okay, thank you very much.
And simply then to round off the second answer to the point raised, Justice Malombo, when there's an issue of functus, that's really saying that you cannot exercise the power. It's not even an interpretive question. It says you have done what you've had to do. Whatever powers the Act may notionally give you don't arise because you are now functus. And that's the point we made earlier about the semantic difference that our learned friends raised. Once you're in the area of saying the commission was functus, it's not really an interpretive exercise on an interpretation of the Act, and certainly not which involves some kind of specialist economic discipline that is required. We say then, if I can just round off, if I can just have a minute to just check my note on things that I may want to deal with before I move on. Anything else in this room? Yes, yes. Perhaps just to also make this point in relation to what was put by one of the justices in relation to the interpretation. 27 doesn't just stop at, 62 doesn't just stop at interpretation. It says interpretation and application. And I think that's Justice Wallace, which said you've got to give those words and application as well meaning. If I can, on the issue of a specialist tribunal, also just direct you to the Beloy decision, and I believe it's paragraph, yes, it's in paragraph 70, where the court dealt with this issue of there being another specialist tribunal. And what was said is, in argument before us, the respondent counsel contended that an intention to exclude the Supreme Court's review jurisdiction should be inferred from the nature and amplitude of the powers granted to the special court created by Section 15 of the Act. Now, of course, it would not be enough for the respondent to show that the special court enjoys powers of review similar to those exercised by the Supreme Court under its inherent jurisdiction. In the present context, the respondent would have to go further and show that the legislature intended such powers to be exclusive. And the court goes on to say it's quite conceivable that review powers concurrent with those exercised by the Supreme Court could be bestowed, as was found to have happened in Pinar's case supra. In such a case, the grant of review powers to the tribunal in question would not mean that the Supreme Court has been deprived of its common law jurisdiction. However, before any suggestion of concurrent jurisdiction can arise, one must examine whether the special court was clothed with any review jurisdiction at all. So we say in the case of the CAT, of course, there's a concurrent issue, but in the case of the tribunal, as clarified Justice Malombo, we say there's no general review power of this nature. So we say the Commission to round this off has to establish not only that this is a case involving the interpretation and application of chapters 2 and 3 and 5, but it also needs to establish that this is not a matter which falls within 62.2. And we say that they've not provided any sufficient justification for that proposition. We say that clearly subsequent, there have been various amendments to the Competition Act after Agri-Wire and all of the decisions where the High Court has exercised jurisdiction or said it has concurrent jurisdiction, and notwithstanding that, and clearly the principle of interpretation that the legislature is intended to know or appreciate the law, at the time of amendment, there was no attempt whatsoever to have a general exclusion or ouster of the High Court's jurisdiction. We deal then with we say that because the case on ouster is so weak, the Commission has to resort to its so-called policy arguments to persuade you of an ouster. And we say those policy arguments are equally without merit. We refer you to our heads of argument, paragraph 50 onward, and in particular, paragraphs 52, 53, 57, 58, 59, and 64, which in essence we say that there's no merit in the Commission's policy argument. There's nothing inherently untoward about a litigant having an election between different fora for enforcing a right. And this was recognized inter alia in Tobayani, quoting from Makanya versus the University of Zululand, where the court said paragraph 50, where the statute offers alternative fora. It's a matter of sheer practicality that the initiating party may choose one or the other. The irony that lies within the notion that in a democratic society, a litigant is denied access to the High Court of competent jurisdiction in the absence of an express ouster ought not to be overlooked. And again, below we say the court there dealt with the threshold and the difficulty of meeting that threshold, that it's not easily presumed. We deal with Metcash in the heads in paragraph 59. We say, similarly, the principle that specialist adjudicative bodies do not ask the High Court's inherent jurisdiction was also made by this court in relation to specialist tribunals in Metcash. We set out the quotation, and at the end of the quotation, the court found, the Constitutional Court found that here, however, the Act provides for its own special procedure for review of the Commissioner's challenge decision by specialist tribunals. But, and this is crucial to an understanding of this part of the case, the Act nowhere excludes judicial review in the ordinary course. The Act creates a tailor-made mechanism for redressing complaints about the Commissioner's decision, but it leaves intact all other avenues for relief. And we say all the more so here, where the reviews that can be brought before the tribunal are extremely limited, that dictum applies all the more so here. And finally, on this point in paragraph 64, and again, we say at the level of principle, agri-wire is good law. Nothing about the amendment renders.
Mr. Bana, you must please take it that we have read your submissions. Unless you just want to highlight certain things, please, you don't have to read your submissions.
We just then draw your attention to that paragraph. If I can just confer with my team justices, I believe that those are our submissions for the purposes of oral argument. If I may have a moment, can I mute myself? Thank you, Justices. Those are our submissions, and we, of course, ask that the application for leave to appeal should be dismissed with costs. We've asked for costs of free counsel. It's clearly an important matter, but the issue of 2 or 3 counsel is obviously in the hands of the court, as it pleases Justice.
Thank you, Mr. Bana. You took exactly the same time as Mr. Ngugaitobi did. Thank you very much. Yes, Mr. Ngugaitobi.
Thank you, Justice Madlanga. I only have 4 themes in reply. The first is just to go back to section 27 on the powers of the tribunal. In fact, it's the functions of the tribunal. So section 27(1) says that A, it's to adjudicate on any conduct prohibited in terms of the Act. Now, clearly that would refer to chapter 2 dealing with prohibited practices. And then B, it's a broader category, adjudicate on any matter that may, in terms of this Act, be considered by it and make any order provided for in this Act. So is in addition an adjudicatory power that is broader than determining prohibited practices. And then there is C, specifically appeals and reviews of any decision of the Competition Commission that may, in terms of this Act, be referred to it. And then D, it's even broader than A, B, and C, make any ruling or order necessary or incidental to the performance of its functions in terms of this Act. So D is a catch-all that applies not on appeals, not on reviews, not on prohibited practices, not on any adjudication, but it has the power to make rulings or orders. This is the power that has been invoked by the tribunal numerous times when it is dealing with exceptions. Now, typically, and the court is aware of this because the court decided Pickfords, typically, the respondents complain about invalid initiations through exceptions before the tribunal. And there was a long debate in the tribunal about whether or not the power of exception was competent or not. But it was ultimately settled on the basis that the power in section 27(1)(d), read with Rule 55 of the tribunal rules, is broad enough. You will see cases like Woodlands. Woodlands ultimately ended up in the SCA. But Woodlands was a decision made by the tribunal on the issue of the validity of an initiation. Pickfords was decided only 2 years ago by this court, also on the issue of an invalid initiation. So there can be no argument at all that the jurisprudence does not establish that the tribunal has the power to decide whether or not an initiation was valid through the exception procedures. And its power statutorily flows from the broad power, which is to make any ruling or order necessary or incidental to the performance of its functions in terms of this act. Sometimes the challenge to the validity of the initiation has been taken under section 27(1)(c). There was a complication with this because of the judgment in Agriwire, paragraph 14. Agriwire found the following in paragraph 14. It says, whilst the section is clumsily worded, now it's talking about section 27(1)(c), if one accepts that it is referring to decisions that the Act provides must be taken by the Commission, the reference to decisions that may, in terms of the Act, be referred to it is a reference to those decisions which are referred to the Commission for it to make in terms of the Act. So I've had my learned friend actually completely muddling up this paragraph because this paragraph is in conflict with what he suggested. The Agriwire found that the reference here to it means decisions that may be referred to the Commission. Now you have two decisions that are in issue in this case. I heard my learned friend says they are also challenging the jurisdiction of the tribunal, but that's just untrue. They are not challenging the jurisdiction of the tribunal in these proceedings at all. The first one is immunity. They say the Commission should have given us immunity. Now, immunity is completely a function of the Commission under section 21 and under section 49E of the Act, totally a function of the Commission. Referral and initiation is completely a function of the Commission. And you see this in terms of section 49, sorry, 50, find the section, apologize. 49B. So the initiation is totally a function of the Commission. It has nothing to do with the tribunal. So the two issues in this case, even if you took Agriwire and you applied it literally, the two issues in this case, the initiation and the leniency, are decisions that are to be taken by the Commission itself without any reference to the tribunal. And that is why we suggested at the commencement that the correct way to approach the case is an analysis of what is the cause of the grievance of the applicant. The cause of the grievance is, I don't like your initiation, but initiation is under 49B. The commissioner takes that decision. It has nothing to do with the tribunal. Second one is you should have given me leniency. Leniency is 49E, again, taken fully by the Commission. It has nothing to do with the tribunal. My learned friend has simply not engaged with those two principal submissions that I made at the beginning, that if you look at the complaint, you compare it with the pleadings, that complaint falls under the powers of the Commission. And therefore, if you applied the standard in section 14 about what is the narrow category to which the review applies, that narrow category would still be, it applies to these decisions because these are commission decisions that have nothing to do with the tribunal. And therefore, they fall under the exclusive jurisdiction in section 62(1)(a) of the Competition Act. If you, however, take a broader approach, which is what we have urged upon the court, that there has to be a segmentation, that's argument number 2. There has to be a segmentation in order for section 62(1)(a) to live comfortably alongside section 62(2). Has to be a segmentation. How do you draw that segmentation? The first is you try to give effect to the powers of the commission and the tribunal to enforce the act. You don't scuttle them by collateral reviews. The second is you give effect to the principle of specialization. So even on the broader construction outside of AgriWire, where you overturn AgriWire and you give effect to the meaning of the act, we say the only way these two can live together, if you have too broad a meaning of constitutional matter, that means you cannot have the tribunal deciding these questions because the tribunal does not have concurrent jurisdiction with the High Court. Only the CAC has. And yet the engine of enforcement is the tribunal, not the High Court.
Mr. Nkaitobi,
Yes,
excuse me.
Apologize.
If we could just go back to the initiation.
Yes.
The respondent is saying the initiation is not competent because the commission conducted some preliminary investigations called research project.
Indeed.
And before the initiation of the complaint.
Indeed.
So where do we then, what do we do with that submission?
Yes. No,
And are they not raising now an ultra vires point?
Yes. The flaw, it's paragraph 67, where they said the flawed initiation. It says the initiation statement records that it is based on the findings of the so-called research project undertaken by the commission. An examination of the contents of the initial statement shows that the research project was, in truth, an extensive preliminary investigation into the suspected contraventions of what? Of the Competition Act. The project involved, at a minimum, the commission conducting interviews with a large number of persons and meeting with various municipalities. Then they say the outcome of the research project was that the commission made certain findings that bid rigging and collusive tendering had taken place in breach of what? Section 4(1)(a) and (b) of the Competition Act. So even in that passage, where they refer to the statutory source, they go back to the Competition Act. But the true answer to the question, Justice Mhlantla, is this. Under section 27(1)(c), is this a matter that they could refer to the Competition Tribunal? Under AgriWire, the "it" referred to it means referred to the commission. Who has the power to conduct an initiation? It is the commission under section 49(b). And that's the full extent of the power. It's the commission. So if you are complaining that the commission's initiation is flawed, where do you go? You go to the place with the exclusive jurisdiction under section 62. So it doesn't really help them to say that another label that could be put on this is ultra vires, because when you do a substantive analysis of the pleading is your initiation is invalid. Who has the power to initiate? The commission. Does the tribunal enter the equation? No, not at all. So the fundamental difficulty our learned friends are unable to deal with, I've listened to their argument, the fundamental difficulty they cannot deal with is that both their complaints, the flawed initiation, as well as the claim that we failed to give them immunity, are powers of the commission. These are matters that the commission is entitled to deal with fully. They have nothing to do with the tribunal. So on the narrow construction of AgriWire, which is their best case is AgriWire. So on the narrowest of constructs, you have to look at the pleadings, and those constructs give you only one outcome. It's 49B as well as 49E. And those are then commission's decisions, and that's where you go. So that's the short answer to this elaborate discussion. So short answer is this Agri-Wire paragraph 14, are these to be taken by the commission? If the answer to that is yes, that's it. Then I don't want to add more on the necessity to segment section 62.2 and section 62.1a. I've made the arguments there in favor of a meaningful approach so that those two sections can live together. The last thing I want to say, well, second last thing, is I've referred to Woodlands and Pickfords, where in Woodlands, the issue around the improper initiation and the improper referral was taken by exception, decided by the tribunal. It came before the CAC, ultimately to this court in Pickfords. Woodlands, it was in the SCA. Same thing with Pickfords. An exception, it goes to the CAC, it ultimately comes before this court. But on both of those cases, it's clear that the issue around the validity of the initiation was dealt with through the mechanism of the Competition Tribunal, CAC, the specialist mechanism. The last thing I want to say to the court with respect, there is no contradiction in saying you have jurisdiction, but the question of constitutional matter under section 62.2 must be narrowly construed. That's the only argument made. You have jurisdiction to interpret section 62.2. What we are asking you to do, with the greatest of respect, is to narrowly construe those provisions so that the statute makes sense. What you have at the moment is a completely insensible interpretation, not only insensible, but indefensible. So in those circumstances, we ask you to grant the appeal, to uphold the appeal, to set aside the SCA's judgment, and to order Group 5 to pay costs.
Mr. Ngutaitobi, just one little thing, just for clarification for myself. If I understand the record well, one of the companies involved in the 2010 stadium issue was granted conditional immunity.
Yes.
Another one concluded a consent agreement.
Yes.
Do those facts matter in any way in the context of this matter, these arguments that we've heard?
Yes, I would say two things, Justice Mlambo, with respect. The first one is that your judgment, the court's judgment in Gaba, which has been followed by Justice Teron's judgment, which is unanimous in Baloyi, says, to decide a jurisdictional point, you must interpret the pleadings, but you should not be influenced by your view on who's right or wrong on the merits. In other words, the merits do not decide the jurisdiction. So to that extent, one can say those facts about whether the commission indeed acted wrongly or not would not be relevant. But there is a second answer to it, which is that Group 5 on the pleaded case was also offered a chance to sign a consent agreement. The dispute that they are alleging is that that opportunity did not included incorrectly the view that the commission had that they were getting 7.5% net profit basis. They disputed that, but they plead that Mr. Shan Rambrund also gave them a consent agreement and asked them to sign, and they refused to sign. So on the equities, on their own pleaded facts, they rigged the bids. They just say we're not the only ones who rigged the bids, and there are others who rigged, and we told you who those people are. But there can be no dispute that if you want to look at the equities, we are dealing with a self-confessed bid rigger.
Thank you.
Justice Madanga, I have nothing useful to add. Thank you.
Thank you very much, Mr. Ngutaitobi. Thank you to both counsel. Judgment is reserved.
Thank you.
These proceedings have concluded. The host will now terminate the meeting.